So we welcome everybody from all over the world in this session. We have a couple of housekeeping rules, as you can see on the screen. Remember to mute your mics. If you have any questions, we'll look at them through the chat box on the left side of your screen. And the only people we will be allowing to share his video is Damon, so that we can avoid any broadband issues with the participants. Remember that each recording will be available once we finish the module. About an hour after that, it will be rendered and available within the module. We'll post it on our YouTube channel, and we will also share it through Facebook and other social media networks. And there's the link for the survey that's in the chat as well, so you can evaluate this session. Next slide, Damon. Next week, our guest speaker will be the CEO or director of the DNS Abuse Institute, which was recently created, and it's sponsored by different organizations. Graham and Button will be with us talking about DNS abuse and internet governance. So having said that, next slide, Damon. Today we have Damon Ashcraft from IPC, and we'll let him introduce himself. Next slide, and the floor is yours, Damon.
Excellent. Thank you so much, Alfredo. Thank you so much, Glenn. It is a real pleasure to be with everybody this morning. I really appreciate you attending my seminar. My name is Damon Ashcraft, and I am a member of the Intellectual Property Constituency. My day job is I am an intellectual property attorney at the law firm of Snell and Wilmer in Phoenix, Arizona, which is in the western portion of the United States. So it is 7 o'clock in the morning here, and it's a beautiful sunny day in Phoenix. It's definitely spring here. It's going to be about 80 degrees today, Fahrenheit. Really glad to be here today. A little bit about myself. I'm a partner at Snell and Wilmer. There's a link to my bio if you're interested. And my practice area is in intellectual property. And so I deal with trademarks, patents, and copyrights. Unlike a lot of trademark attorneys, I also handle patents, which is something we don't talk a lot about sort of in the internet sphere because they don't quite touch as much on that, but I am a registered patent attorney. I have been involved with internet governance, and I say I'm an ICANN volunteer since 2016. I actually joined the IPC in 2014. I just really say I started in 2016 because I attended my first ICANN meeting in 2016. And that's what really got me sort of plugged in to the ICANN community and into the Internet Governance Committee. With respect to my roles within ICANN, I have been a member of their nominating committee. And if you're not familiar with that, the nominating committee is the committee that fills a lot of the leadership roles within ICANN. With respect to ICANN's board of directors, the nominating committee fills about 50% of the board. And thank you very much, Alfredo. I mentioned an acronym, so thank you for clarifying that. That's great. They also fill different leadership positions on the Generic Name Supporting Organization, or GNSO, the Country Code Naming Support Organization, or CCNSO, the ALAC, the At-Large Advisory Council, and they do a couple other positions as well, but those are the main ones. I represented the Intellectual Property Constituency. I then joined the leadership of the nominating committee and went through the normal rotation, which is your chair-elect. I was chair in 2019, and then I was associate chair last year. Currently, I am a member of the Intellectual Property Constituency and its treasurer. So I work on managing the money and harassing IPC members for dues payments. We're going to go over today, and we're going to talk about the legal aspect of internet governance that I want to talk to you about is trademark law and how it relates to domain names. That is a topic that I think gets a lot of attention, and I wanted to go ahead and sort of go over it. and to discuss it and have a discussion with you all today. When I give these styles of presentations, I don't want it to be me just talking for 45 minutes or an hour. This presentation is for the group. If you have questions, please put them in the chat and we'll stop and we'll go ahead and we'll take as many of those questions as we possibly can. Also, another thing I want to mention is, I am a trademark attorney, and I know that just in the realm of internet governance, that sort of puts me on sort of one camp of things. I don't want this presentation to be all about trademark law and why trademark attorneys and trademark owners are always right. That is not the point of this at all. This is a point just to go over what is the legal standard, what rights does a trademark owner have relative to domain name registrants, and then what rights do the domain name registrants have? I know there's a big concern. I talk to a lot of people and they say, well, wait a second, we think that trademark owners have too many rights. What rights do I have? What rights do I have just as a regular citizen when I register a domain name? And when do those rights supersede a trademark owner's rights? We want to go over that as well. The general format of our presentation is we're going to discuss what is a trademark, and then what rights does it give the owner, and then we want to talk about those rights relative to domain name registrants. And there's different forms of dispute resolution that registrants and trademark owners can engage in when there's a dispute over a domain name. They include traditional litigation, and then there's also a whole bunch of alternative dispute resolution. And the alternative dispute resolution proceedings, those include the UDRP, which is the Universal Domain Dispute Resolution Policy, or Domain Name Dispute Resolution Policy. We'll talk about that a little bit more in detail. We have a question here about, is a trademark concept a global concept? Alfredo, that's a really good question. When we talk about trademark law today, we're going to be talking about, we're not going to go into any specific jurisdiction per se as to what a specific law or statute is other than the UDRP. We're going to talk sort of in general concepts as to what rights trademark owners have around the world. So we'll be speaking sort of in general terms. It's also real important to note, though, that trademarks are territorial in nature and they're jurisdiction based. So a trademark owner, if I own a trademark within the United States, my rights do not go outside of the borders of the United States unless I take certain steps, either through use or registration, to register them in another jurisdiction, whether it be Canada, whether it be Europe, China, etc. So my rights are very territorial. What is a trademark? Trademarks are words, taglines, symbols, and logos. And so, for example, for example, we'll talk about, what is a word trademark? Coca-Cola, taglines, symbols, logos, etc. What are some famous, what are some trademarked logos? The star from Mercedes-Benz automobiles, the NBC peacock. Taglines can also function as trademarks. These are typically slogans, etc. For example, there was one, I don't know if they still use it, they call, I think it was United Airlines. It was "Fly to Friendly Skies." That would be a tagline. And these are things that allow us as consumers to associate certain goods or services with a source. And a good example of this is, I remember a few years ago, I was at a park, and this is before I had kids. It's been quite a few years ago. And there was a balloon race, and it was a hot air balloon race. And I was sitting there with my wife, and we were surrounded by all these families, and the balloons would go up, and the balloons would have different logos on them. And you'd have a balloon, let's say, for example, with the golden arches for McDonald's. Remember, there was a little girl. She was about 3 years old, and she was next to us, and she pointed to the balloon, and she said, McDonald's. And the word McDonald's was not on the balloon. Wouldn't have mattered. She couldn't read. She was probably too young to read. But she recognized those golden arches as symbolizing McDonald's and their food. So what trademarks do is they force us as consumers to associate the goods and services with a particular source. So if you're, let's say you're at the airport and you see the widget on an airplane, you can associate that airplane with Delta Airlines. In addition to that, there are also marks that could be sounds, and there are non-traditional marks. For example, the chime there with NBC, that is associated with NBC with their broadcasting network. How do trademarks come? How does the trademark owner get rights? They get rights through common law, which just means they're using a mark. So you open up a restaurant and you just start calling it Glenn McKnight's Restaurant. If you keep using the words Glenn McKnight's with restaurant, you will get trademark rights in Glenn McKnight's as associated with restaurant services. The other way that trademark rights can arise is through registration. And registration occurs at the various different trademark offices around the world. And it's a formal process to register your mark, and you get rights through a trademark office. And again, these are jurisdictionally dependent. So if I have a trademark right in the United States, I don't have anything outside the US. I don't have anything in Africa. I don't have anything in Asia until I go out there and I affirmatively take action to get rights, either through use or registration. The other thing that's unique about trademarks is that there is no expiration. Other forms of intellectual property expire. Patent rights, they expire after 20 years in most jurisdictions. Copyrights, they last a lot longer. They might last 100 years, but they too expire. Trademark rights just keep going. As long as the owner continues to use it, those rights will basically exist for as long as the use continues. Why do we have trademarks? Well, really, it's grounded in a public policy argument. And the reason is we want to protect consumers. We want consumers, when they see a particular mark, to know what type of quality of goods or services they're getting with the goods or services associated with that mark. So, for example, if you're shopping and you see the Tommy Hilfiger mark on clothing, you have a general idea of what type of quality of goods or services you're going to get with those with those goods. And that's why counterfeiting is such a problem. When you start counterfeiting, and when people have used counterfeit goods and they use a mark on them illegally, that removes that public policy argument, because then oftentimes the counterfeited goods are of a much less quality than the genuine goods. And so that's why it's real important that trademark owners and courts enforce their rights to shut down counterfeiters, so that you know as a consumer that when you're buying something online and when you go to the Amazon website, that you're actually at the Amazon website, and you're not at some fake website that's going to take your money and then not deliver you the goods that you ordered. Does anybody have any questions about sort of what trademarks are, or the public policy, or anything like that at this point before we go on?
Damon, this is Alfredo. You just made an interesting point, and I just want to see if I have it clearly. So let's say that I'm a consumer and I purchase things through Amazon.
Yep.
Does Amazon have some regulations or among their policies that whatever they're selling isn't counterfeit, or it's the real thing, or actually, how do they protect me when I purchase something online?
Well, that's a good question, and I don't know the specific Amazon policies off the top of my head, but I imagine that they do have some type of policy out there that says that you can't sell counterfeit goods on Amazon. When I was referring to Amazon, I was referring more along the lines of is that if you're online and you go to a website that's branded Amazon and it has the banana on it, the banana logo on it, that a goal and a principal aspect of trademark law is that you're actually on a website affiliated with Amazon, that you're not on a website that's affiliated with some darkroom actor that's using Amazon's marks on a website that when you purchase goods from it, they're going to take your money and not ship you the goods.
Okay, great. So I imagine that infringes or ties in with IDNs and the DNS abuse concepts.
It does. It does. It depends. It would infringe upon. The infringement could be if you have a website that has Amazon or something that's similar in the domain name. That would be an issue of domain name abuse. Alternatively, if you have a website that doesn't have Amazon in the domain name, but it has Amazon all over the site itself, that would be an issue of trademark infringement, but not necessarily of anything related to anything online.
Thank you.
Let's talk a little bit about trademarks in strength, because how strong a mark is going to dictate as to how far your rights are going to go. If you have a really strong mark, you're going to have strong, far-reaching rights. Alternatively, if you have a weak mark, your rights are not going to be nearly as strong, and they're going to be much more limited. What is a strong mark? Strong marks are arbitrary or fanciful words, things that are made up. So, for example, here in the United States, we have a company called Xerox. And what does Xerox do? They make copy machines. Well, when you see the word Xerox, you probably have no idea what it means because it has no meaning. It's just a made-up term. So if something is made up, if it's arbitrary, if it's what we deem in trademark land to be a quote-unquote fanciful term, that's going to be a strong mark. And then in addition to that, there are marks that are legally considered famous because they are so widely used and so widely recognized that people see them and that they have a different presumption of strength, and they're called famous. So an example of a famous mark might be Mercedes-Benz for automobiles and trucks. Alternatively, what do you have on the other end of the spectrum? So trademarks are either strong or they're weak or they're in between. So we've spoken about strong trademarks. Weak trademarks are those that are generic. So for example, if you call your restaurant, that's going to be a very weak mark, and it's going to entitle you to very weak, if little, or very or almost no protection. Generic marks are basically marks that describe the generic genre of the services or goods that you're providing. And restaurants are a great example. Then you can have marks called descriptive marks. Descriptive marks are marks that describe your goods or services. So if you're in the restaurant business, again, we'll pick on restaurants. If you say you've got tasty sandwiches, well, tasty by itself isn't generic for the word sandwiches, but it describes an attribute of your sandwiches, which is they're good. Geographically descriptive terms also fall in this descriptive element. So for example, the sandwich and bakery Paris baguette, that is going to be a descriptive mark. It uses the word Paris to denote that it is something from France, and then baguette, which is a generic term. So not a particularly strong mark for the folks at Paris Baguette. So let's talk a little bit about domain names. There are numerous laws and policies that have been set up to protect trademark owners from what are deemed to be cyber squatters. And cyber squatters are individuals or entities that register a domain name with a trademark or something that is similar to a trademark within the domain name. And the point of a cyber squatter is to confuse consumers. So you've gone out there and you've registered the domain name with the intent of using someone's mark in it to confuse consumers. And there's a key thing in here. A cyber squatter is not any individual that has a domain name with a trademark in it. That is not a cyber squatter, because there are many people that have trademarks in their domain names and they're not at all liable for cyber squatting, and they haven't done anything wrong. Because cyber squatting, as we see as we go in there, we'll talk a little bit about what the law actually says. It requires that there be an element of bad faith. So if you go and you register a domain name and you have a trademark in it and you don't have a bad faith intent, you're not at all a cyber squatter, and you should legally be able to use that domain name. So for example, we talked about Mercedes. If you go and you register the domain name Mercedes Parts, and you're selling automobile parts for Mercedes-Benz automobiles, and your intent of registering that domain name was to basically get people that were looking for Mercedes-Benz parts and get them to go to your website, that's probably bad faith intent. But let's say, for example, you register the domain name Mercedes Parts and your name is Mercedes. In that case, and you have no intent and no desire to confuse anybody, you just want to use your own name in your domain name. Is that bad faith? Absolutely not. So what happens when we get involved when there are disputes between trademark owners and domain name registrants? What a trademark owner needs to show is they have to show a series of elements in order to prevail in these types of disputes. And they have to show each and every element. It's not good enough for a trademark owner to show one of the elements or 2 out of 3 elements. They need to show all of the elements in the particular jurisdiction to meet the particular law that they're trying to say was violated. And again, these are going to be in very general terms. But one of the elements is you have to show that you have valid trademark rights. Trademark owner can't come along and say, well, I think I have rights in this. They have to actually show they have a valid trademark, either at common law through use, or alternatively through a registration scheme. And typically, these registered trademarks also require use, or in order for you to assert them, you have to have use for them to have any strength. You also have to show that the domain name incorporates the mark in its entirety and that it's confusingly similar. So you have to show the domain name has to have the mark in it, or it has to have something which is deemed to be, quote unquote, confusingly similar. What is a term? What does it mean to be confusingly similar? Well, that's how lawyers make their money. It really depends. And it really is one of those things where you have to look at each particular instance and say, yeah, that's close enough to be where we think it is going to be confusingly similar, and that it's, basically it's a similar term, etc. So, for example, let's say, for example, that you want to register, or someone registered. Wait a second, I've got a question down here from Alfredo. Denny's restaurant versus Denny's restaurant. So that's a good example, Alfredo. So basically, are you talking about the difference with just the inclusion of the apostrophe? Okay. Yes, that would probably be something that's confusingly similar because it is so close. If you're representing Denny's restaurant, and the only difference is an apostrophe, that's going to be real close, because that's a mistake that someone might make when they were looking for Denny's restaurant. So that's going to be something that's confusingly similar. Another example, sticking with Denny's, you might have, for example, what if you had, instead of the Y, you had a phonetic equivalent? What if you had Denny's, D-E-N-N-E-E-S, instead of the Y? Show in the chat, how many people think that would be confusingly similar to Denny's with the Y? David says, not so much, not for me, not from June. Rakesh says, yes, it confuses. Olivier says, no. So that's really a good example. What's the right answer? I don't know. That's something that I think that would probably be litigated and discussed. Does a phonetic equivalent constitute confusion in that instance? We don't actually know. I think that's something where it could go either way. You could make the argument, I think it'd be 100% correct, that look, the two E's is different than the Y, and that therefore there's no confusion. And you could also make the equivalent and say, look, it sounds the same, there is confusion. So that's an example, and it could really go two ways in that. Also, with respect to what is confusingly similar, this includes typos, or so-called typo squatting. So oftentimes what I'll see in my practice is there'll be domain names, they'll have a trademark in them, but they'll just have an additional letter attached to it. They'll have a misspelling. Those are things by themselves. If it's a common typo, if it's an easy typo, that's still going to be considered to be confusingly similar. What else do you have to show? And these are the key things. And these were, I think, most people that are domain name registrants that are defending themselves these are the two elements that help them out the most. The domain name has to be registered in bad faith, and it has to be used in bad faith. And that's not one element. That's two separate elements. So you have to show that the person registered it with the intent to defraud people, to rip off the trademark owner, and then you have to actually show that they used it in that manner. The bad faith element is almost always going to be the key. The inclusion of a mark, whether or not it's confusingly similar, despite the fact we had this good little debate about Denny's and Denny's with two E's, typically speaking, most of these disputes, a judge or a panelist, a UDRP proceeding or another proceeding will look at it and they'll make an opinion pretty quick as to yes, that has the mark, or no, it does not have the mark in it. And in many cases, the exact mark is in the domain name. And if that's the case, you're not going to be able to refute that and say, well, the mark's not there when it clearly is. So bad faith is really the key. And remember, the trademark owner, they have to show that it was both registered and used in bad faith. What does bad faith mean? Well, it can be broadly interpreted, and it can mean a whole lot of different activities. It could be things that I think that are fairly obvious. For example, if you have a website and we'll use Hermes, for example, which is the overpriced, luxury goods for handbags and other things like that. If you have a website and you register HermesHandbags.com, and you go to a website where you're selling knockoff handbags with the Hermes marks on them, that's going to be bad faith. You're not really going to be able to show that it's not bad faith because you're doing it for an illegal activity, which is selling knockoffs. But there are also other things that people do when they register these domain names that gets them into the bad faith category, or how bad faith is interpreted, that I don't think is as obvious or intuitive to a lot of folks. For example, you have a website, you use the trademark of the domain name, and the website, when people visit it, has nothing to do with the goods and services, but it is populated with a whole bunch of different ads and links, a bunch of clickbait on it. That is often considered to be bad faith. What about just a blank holding page? You go there and simply doesn't resolve to anything. Is that bad faith? In many jurisdictions and with many alternative dispute resolution policies, it is. Other things that constitute bad faith are offers to sell the domain name for above registration costs. One of the things that I see people do when I represent trademark owners, that is frankly a mistake people make on the other side, is they get a demand letter and they go back to the person that wrote them the demand letter and they immediately make an offer. They say, you know what, I'll sell you the domain name for $10,000. Offers to sell a domain name or transfer registration of a domain name for excess of what you paid for it is considered to be bad faith in most of these dispute resolution policies and under most of these laws. So if you register a domain name and you get a demand letter, probably the worst thing you can do is to go back and say and make an offer to sell. We're going to talk about in a few minutes as to what people should do and what will cut against that bad faith argument. But offering to sell it for an excess of what you paid for it is generally going to be considered bad faith. So what is not bad faith? Legitimate use. Legitimate use is businesses. It is causes. It is anything where you are not there to trade off the trademark owner's rights. And it includes criticism sites. So let's say, for example, you book airfare on South African Airways and you have a really bad experience. The flight's delayed, they lose your luggage, and the food's terrible. And so you really want to tell people about how bad South African Airways is. So you register SouthAfricanAirwaysSucks.com, or better yet, you use the GTLD.sucks and you say SouthAfricanAirways.sucks. Is that bad faith? It's not, because in that instance, in June, this is just an example. I've never actually flown South African Airways. So hopefully you say their food's good. So I will trust you that it is. But in any event, let's say you register a website to complain about South African Airways. That's not going to be bad faith. But let's say, for example, that you do that, and then all of a sudden you're like, you know what? I can, and let's say you have a competing airline. I'm going to sit there, I'm going to have this website, and it's going to criticize South African Airways, but then I'm going to start, I want people to use you own a travel agency service. We're post-COVID, and you have a travel agency service, and you decide, you know what? I want people to go to this website, and then I want them to go to my service so I could book them airfare on any airline, and then I can make money off of that. Is that bad faith under those circumstances? What do people think? Fredo says not good. Not good. David says not good. So in that instance, grab my pen here. That is an example of bad. I think it could turn. It could go either way, but I think that probably would be considered bad faith. Now, if you're South African Airways, are you going to be able to, should you win a UDRP complaint against that situation? I say absolutely not. You know why? Because you don't meet all the elements. You may be using it in bad faith now, because now you're using that website. You're not using it so much for criticism. You're using it to basically drive consumers to another website so you can make money off of it. But you know what? You didn't register it with bad faith. So South African Airways can't show all the elements. And because they can't show that registration element, they should not win a UDRP in that circumstance. Now, one other point I want to make is it is easier to prove trademark rights in bad faith for marks that are strong. For example, if you're using the word Xerox or another strong mark in a domain name, it is going to be much harder for you to show that this was not a bad faith attempt, because those are arbitrary and made up words. But if you're using a mark that is weak, geographically descriptive, those are going to be marks where it's going to be easier to show that there is no bad faith. So, for example, there's a company called Toledo Scale, and they make scales. Their mark is Toledo. There's also a city in Ohio in the United States called Toledo. So if you have a domain name that talks about ToledoWeightsAndMeasures.com, and you're based in Toledo, Ohio, that's going to be a situation where you're going to have a good argument that there is no bad faith. And the Toledo Scale, as the owner of that mark, they're going to have an issue because they have a mark which is geographically descriptive. And there are many examples of marks that are geographically descriptive. And because of that, those trademark owners have a harder time with enforcement. Other examples of bad faith. Offer to sell the domain name in excess of registration fees. We talked about that. A site with no real purpose. If you go to a website and it has a trademark and it's just a bunch of links, if the only purpose can be to derive revenue for the registrar without any other real goods or services, that's going to fall more in the bad faith category. Techniques to sell competitive goods, that's bad faith. Redirecting to the trademark owner's site. That's another big one that I think a lot of people don't realize is bad faith. But if you set up a website, let's say you set up the website AmazonPrime.com and you redirect to Amazon.com, that's going to be considered bad faith. And Amazon would probably have a real concern with that, because while it's not a problem when it's redirecting to their site, they're going to be worried that, oh, wait a second. What happens if you redirect that domain name to another third-party site and we don't know about it? So that's another example of bad faith. So how do folks defend themselves against claims of cybersquatting? Well, first off, when you're registering a domain name, make sure you have a genuine intent to use the domain name. I mean, if you're going out there and you're registering a domain name, and the only real reason you're registering it is to sort of trade off a trademark owner's rights, you're not going to have a good defense if you get hit with a cybersquatting claim. But if you have a genuine use, Those are good defenses, and they rely to the fraud element, or not the fraud, but the bad faith issue of registration. So if you register a domain name, communicate once you get that cease and desist letter from the trademark owner. Don't sit there and not communicate and not write back, because what happens is that if you don't respond, the non-response in many jurisdictions is considered to be bad faith. And also, the non-response, there's nothing there that if this ever goes before a panel or a judge, that the judge can look at it and say, well, what was your legitimate use? You have to prove up and you have to establish, well, I shouldn't say that, no, you don't have to prove, you have to show some legitimate use, but the burden is on the trademark owner to show that they have that they have rights and that you have bad faith. You just have to rebut that. If you have a UDRP or another type of similar complaint filed against you, and you have a legitimate use, you should respond to the UDRP complaint. The rules are for the UDRP complaint is that if there's no response filed, everything that's in the complaint is considered to be true. And so if you have a legitimate use, you should file a response. And another thing folks should do if, to defend against a claim of cyber squatting is document what your plans are. If you want to have a business and a domain name is key to that business, have a business plan. You're going to need a business plan to raise money, to get loans, etc. That plan should mention your domain name and why you have that domain name and why you want to use it. If a trademark owner files a UDRP complaint against you and you go back to the panel and you say, no, this was in my plan, I wanted to have this business, here's the plan for the business, it's going to be much more difficult for that trademark owner to show that you've had a bad faith intent to register and a bad faith intent to use the domain name. Keep records. It's another important thing that folks want to do is to make sure that, as they're going out there and they're planning to operate, whether it be a business, whether it be a charity, whether it be just a website directed to public interest, that you have records of what you're doing and why you're doing that. For example, let's say, for example, you want to have a website that is dedicated towards the history of airlines. And you have a airline name in your domain name. And the point is your entire, let's say, for example, we'll use South African Airways again. And you register South African Airways history. And the point of you registering that is that, unlike our previous example, you love South African Airways. You think they're the greatest airline in the world. And you want to have a website that discusses their history as an airline. And so you've gathered all these documents, you've read books, etc. Document all that before you register that domain name. Be able to show to an arbitrator or a judge and say, look, judge, no, I'm not trying to rip South African Airways off. I love them. And here's how I've gone. I've read all these books on South African Airways. I've gone ahead and I have a Facebook page, which is a fan site of theirs. And I register this domain name for the sole purpose of being able to highlight their history. That's going to be an example of something where they're going to have a hard time showing bad faith. We've talked a little bit about what to do, what not to do. Ignore claims of infringement. Don't talk to the person. Even if you think that they're a horrible, mean trademark owner and the lawyer is mean, they're terrible, they're bullying you, whatever it is, talk to them. Go back and start giving them evidence to support the fact that there's no bad faith intent. Do not make a demand payment for a domain name. Even if that's something that you may want, you may be interested in selling the domain name, that should never, ever, ever, ever be the first thing that comes back in response to a cease and desist letter. Because that's going to be clear examples of bad faith. Arbitrators, judges, they see that and they latch onto it. claim it's mine because I registered it. No, you cannot just say, well, I should be able to register any domain name I want with any trademark in it I want because I registered it. You may feel that way, but that's not what the law says. So it's not a helpful exercise to make a claim like that. I would avoid registering domain names that have well-known trademarks in them unless you have significant evidence of your legitimate use. And I will give you an example. Here in the United States, there is a company called Blue Cross Blue Shield, and they're in the healthcare industry. Blue Cross Blue Shield is extremely aggressive about enforcing their rights online and everywhere else. If you're going to register anything that has Blue Cross Blue Shield in it, you better have a good background and good supporting documents to show why you don't have bad faith. That's pretty much it. So that's my presentation. What questions do I have? And I hope this has been helpful to you. I hope it's answered some questions for you. But are there additional questions that I could answer in our time remaining this morning?
Great. Thank you so much, Damien. That was very insightful. I want to relay, I typed it in the chat, but back in the 90s, I had the rights to the South African product called Beijing or Freeplay Radio.
Okay.
And they had a problem. They had a cyber squatter, a chap from Amsterdam, who posted, who actually grabbed the domain name, and he was looking at $10,000 to be compensated for it. And when he found out that it was a not-for-profit organization and the radios were helping education in different parts of the world, and especially with the AIDS epidemic, and he ended up giving the radio the domain name www.beijing.com for 2 radios. So that was a pretty cheap exchange. I thought it was something that even though he didn't have the rights to it, or it was a pretty far stretch, but I figured grab it when I could. So at some point, I guess you have to decide on how far you want to fight something. So that's just
Absolutely.
My experience.
And that's a good example. And I think it's always positive, Glenn, when trademark owners and registrants can work out a dispute amicably amongst themselves, particularly, to benefit society as a whole. We had a pro bono case at our firm several years ago where a maker of child safety seats for cars sent a client of ours, I think it was a pro bono client. It was an organization. I don't know what the specific facts of the case were, but they sent him a pretty aggressive cease to desist letter. And we wound up getting a resolution for our client whereby the trademark owner, because this was an organization that basically provided child safety seats to low-income families. And here in the United States, basically, in every single state, children pretty much under the age of 10 have to be in some type of child safety seat. And you can't ride around with a child or a baby that's not in one of those seats. These seats are expensive. They're anywhere from $150 to $500 per seat. And obviously that's something that lower income folks are going to struggle with to purchase. And we were able to get a resolution whereby the car seat maker sent like 300 of these seats for free to this organization that could then give them to these parents in need. So those types of resolutions are always positive. Alfredo, you had a question, AmericanAirlines.news. Can I ask you to expand upon your question about that?
Sure, Damon. My question, when I use that example of American Airlines .news, is if I have that domain name and I want to use it to share fake news, for example, or bad news about that airline, for example, is that acceptable, or does the company American Airlines have the right to dispute that, and I can lose the registration of that domain name?
Well, I think they would have a right to dispute it, The issue would be whether they win, because it does have their trademark in its entirety in it. Now, when you say fake news, do you mean fake news as sort of news that's just not true about American Airlines? So, for example, saying American Airlines, you're going to have a story on there that says American Airlines, 1 out of 50 flights, one of the engines fails, and that's totally false? Or do you just mean posting information that's negative about American Airlines, such as, for example, American Airlines, their flights from Phoenix to London are late 50% of the time?
All of the above. And the last example that you made, let's say that instead of saying 50%, I say 75% or 80%.
True. No.
Yeah. So the question is that the airline could present stats that refute that, and they would win the case.
Possibly. I mean, in a case where you're just posting stuff, if you're just posting negative facts about American Airlines, such as they're late, let's say they're late. Their flights from Phoenix to London are late 30% of the time, and you post that. There's no bad faith. That you're just posting the fact that American Airlines. You're posting a fact. They're late 30% of the time. Let's say you post a video of American Airlines of a ticket agent being rude to a customer. That's perfectly fine. Now, let's say, for example, you decide, you know what? Yeah, they're late. We know they're late 30% of the time, but I'm going to say they're late 60% of the time. And you start basically things that are not true about them. And that criticism becomes more of a, not really telling legitimate criticism, but you're then sharing sort of falsehoods about them. In that case, then it cuts more towards bad faith. Now, AmericanAirlines.news. Let's say, for example, that site goes to BritishAirways.com. And British Airways is the registrant of AmericanAirlines.news. Is that a case you think is easily? What do people think? Show me in the chat. Should American Airlines win that UDRP complaint? Glenn says yes. David says no. Alfredo says no. I would tend to agree with Glenn, because in that case, you're using the mark in its entirety, and then you're directing it to a competitor. And a court is probably going to look at it, and they're going to say, you know what? You're just using the American Airlines mark, and people, when they go to it, they're going to think they're going to try to get some type of news about American Airlines, and then they're going to be directed towards British Airways. If that's the case, they're going to be confused, and they're going to sit there. Once they get to British Airways site, they might say, you know what? Instead of booking this flight on American, I'll book it on BA. In that case, that's probably going to be considered bad faith. Now, trick question. Let's say, for example, you start AmericanAirlines.news, you're British Airways, and you start AmericanAirlines.news with the intent to share news about American Airlines. You register the site, and you have all this news about American Airlines and their membership in the One World Alliance, which also British Airways is in. You do that for 3 months. And then you're like, forget this. We're just going to send it directly to our regular landing page for British Airways. Should they win a UDRP complaint? Yes or no? Type it in the chat, yes or no. I'll give you a hint. The answer is no. And the reason is there's no registration in bad faith. There's use in bad faith. They became dirty dogs, but they didn't start off as dirty dogs.
So Damon, I do have another question.
Sure.
When these situations come up within about domain names, what organization is in charge of dealing with that and resolving the dispute in case there is one?
Sure. Well, there are lots of different organizations. Depending on your jurisdiction, you may have there may be certain laws in the jurisdiction. So if you're in the United States, there's what's called the Anti-Cybersquatting Consumer Protection Act, or ACPA, and you can take someone to court for cybersquatting. Now, the key thing for that case to be successful is you have to have jurisdiction over that person. So, if I go after Glenn's a Canadian citizen. I might be able to win a judgment against him, but I'm not going to be able to collect anything because he lives in Canada. And so the court's jurisdiction doesn't go very far as collection goes. Now, for example, other mechanisms that decide these types of things, if you're in an alternative dispute resolution process, such as a UDRP, there are two main providers. One is called the Forum, which, by the way, has a horrible trademark. We'll say the Forum. It's totally generic and descriptive. They can decide these UDRP complaints. There's also WIPO, the World Intellectual Property Organization. They also adjudicate these disputes as well. And by the way, anytime you register a domain name that's a top-level domain name, such as .com, any of the quote-unquote new GTLDs that are now like 7 years old, those are all subject to the UDRP. So by your registration of those domain names, you're agreeing to be bound by the UDRP procedure. But understand that a key aspect of the UDRP procedure is that if you lose, you can appeal that to a court within 10 days of losing. And it basically stays the entire transfer.
So, Damien, we have time for one more question. It's from Rakesh. He's typed it in the chat here.
Sure.
He's basically saying, I assume, what are the economic issues resolved associated with trademarks? And he goes on, how are they resolved?
When you say the economic issues, Rakesh, could you clarify a little bit what you mean by that?
I don't see Rakesh typing. I'm not actually sure. Oh, he's typing right now. Just give it a second.
Yeah, Rakesh, you can
kind of damages, like what could like payments?
Payments.
Okay. So I'm assuming you're meaning like, so what if you're a trademark owner, how much money can you get against an infringer? In the alternative dispute resolution, like the UDRP, nothing. They don't award any financial damages. If you're in traditional litigation, let's say, for example, in the United States, if you file and you win an ACPA claim or an Anti-Cybersquatting Consumer Protection Act claim, your damages can be, you can get statutory damages as high as $100,000 per infringement, and then plus if you could show other damages through the infringement, you can recover those as well, including lost profits, etc.
So we're over the top of the hour, Damon, and I would like to thank you for your excellent presentation. You covered most of all of my questions, and I guess everybody else's questions. Glenn, any last words?
No, this is fantastic. And if there's any articles or resources that you feel it would be valuable for any of our participants and ourselves, feel free to email me, and we're happy to incorporate them into the course. This is a fantastic opportunity to have you on this topic, and I knew it would be a great topic. I know your expertise, and I feel it's a very important topic for everyone. So I learned a lot. So this has been great.
Well, thank you, Glenn. Thank you so much, Alfredo, and thank you to all the folks that attended this morning. It's been a real pleasure. I've really enjoyed this, and I just wish you all the best as you go through the Internet Governance School. Fantastic program, and thank you for having me.
Great.
Thank you. Okay. So we end this call, this session.